Welcome back to another discussion on cannabis, startup companies, and the law. Our cannabis attorneys are often asked to guide early-stage companies in structuring their hiring systems. More precisely, navigating the tricky path of bringing on full-time employees versus contractors raises a multitude of issues and is worth briefly reviewing. Fundamentally, choosing the former over the latter will be a function of both the duration and exclusivity of the individual's working relationship with the company. As a general rule, the longer and more dedicated the worker's commitment to the company, the greater the likelihood he or she will need to be hired as an employee rather than as a consultant. Naturally, early-stage cannabis companies are often cash poor and understandably strive to keep costs to a minimum. Hiring new workers as employees instead of contractors will be more financially burdensome, but under certain circumstances necessary. Indeed, companies are required to provide their employees with workers' compensation insurance, employment compensation, and a variety of other job benefits that contractors are not entitled to. While tempting, misclassifying workers as contractors instead of employees is risky and may result in onerous federal and state penalties. If a given cannabis company desires the worker to be in their exclusive employ on a regular and full-time basis with fixed wages, they must treat and classify the workers as employees. Traditionally, consultants are brought on to handle very specific needs and problems. Consultants have a specialty in a given field and offer solutions on an as-needed basis. Employees, conversely, are hired on a long-term basis and are expected to work on a variety of issues and projects as they arise throughout the year. Consultants are generally paid on a per-project basis and do not receive salary. Cannabis companies may negotiate a fixed fee for a set task, and it is understood that the relationship with the consultant is over upon the completion of the task. Employees are offered a payment structure that may include a set salary, stock options, or a combination of the two. In either case, the financial arrangement is more permanent in nature and does not expire after the completion of a single project. Consultants must explicitly release their rights to their intellectual property in order for the employer to legally use them. If they do not sign an IP release form, the consultant retains those rights and can bar the company from using the proprietary IP. Employees, however, have far less presumed ownership to IP created while they were employed. Creation of the IP on the employer's site may be enough to automatically render it the property of the company. Here are our final thoughts. This is serious business, pun fully intended, and the falsification of a worker's legal status may have very serious financial and legal repercussions. Is the worker there to complete a series of projects? Is the worker stationed at the company for an extended period of time? Is he or she working on a core feature of the company's business model? If your answer to these questions is yes, you are likely hiring an employee and not a contractor. We look forward to hearing from all of you. Please visit our website at www.thclegalgroup.com.